I have tried to imagine what it all must have looked like from Joe Johnson's perspective. Presumably, he felt like PlainSite was shining a spotlight on him unfairly. This thought exercise wasn't always easy to do because I knew so little about him, but I could make some reasonable assumptions. That he was born into a black family without much money. That he was a smart kid who didn't have the right support structure to encourage his intellect. That he probably viewed his first incarceration in Virginia as unjust. That perhaps he saw white people and the corporations they ran as the enemy, and maybe therefore exempt from the rules of fair play. Those are all just guesses, but even they can't fully explain it because for years, Ursula Burns was the CEO of Xerox, a company he sued again and again. Miss Burns is one of the few African-American CEOs the Fortune 500 has ever had, but maybe Johnson didn't know that. So as hard as I tried, I just didn't get it. Johnson probably wanted to get a job, and having his lawsuits plastered across the internet probably wouldn't help much with that. But if you file 100 lawsuits, can you reasonably expect the whole world to keep them all secret? Or maybe it wasn't about getting a job, maybe it was just about the cash. Though surely there had to be an easier and faster way to make money. Thanks to Oliver, who had bowed out along with Public Citizen, but had managed to take a photo of a public terminal at the court before he did, I'd seen one document confirming a $2,500 settlement. Yet some of Johnson's cases were about tiny amounts, like $300. Unless he was desperately broke, which he clearly wasn't driving a BMW, why even bother? It was irrational. It was infuriating. It was eating up my time, and it was about to start costing Think real money. It didn't matter that I could do this all myself. As a corporation, Think needed to hire a lawyer. So I made about 50 phone calls and sent a few dozen emails to people I didn't know, praying for a response, and then, if I was lucky enough to get one, I had to explain that I was a person with an irrational problem that wasn't my fault, and that the problem involved a vexatious litigant who had a history of going after opposing counsel. Not only did this feel like an invasion of my privacy each time I had to explain it, but it felt like I was becoming someone with a victim complex pleading for attention to my fate. Yet there was no other way to do it. Some of the lawyers I talked to were obviously unqualified, but it was always fascinating to hear them talk themselves up as if they were, unaware that I knew how to call their bluff. I'd pull up their profiles on PlainSite or create new ones since Maryland's data is so spotty, and find their typo-filled briefs, their sad client lists, or the fact that they hadn't been in a big case in 20 years. Everyone wanted money. $25,000 retainers seemed popular. Several demanded evergreen retainers, referring not to pine trees or those little air fresheners that hang from your car's rearview mirror, but never-ending cash. As soon as part of the retainer is depleted, you have to refresh it right away. What's evergreen for the lawyer is ever red for you. After talking to about 5 or 10 law firms of varying sizes, I was worried that I was running out of options. There are a lot of lawyers in Maryland, but there are not a lot of First Amendment and libel lawyers. And in fact, in the end, I could not find a First Amendment or libel lawyer in Maryland to represent Think. I failed. Or you could say that with lawyers pricing themselves out of their own market, the system failed. The lawyer I ultimately found was a guy named J. Dirk Schwenk. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. I sometimes do wish, for a second here or a second there, that I had gone to law school. Then I would be able to represent any issue, any person, or any company I wanted to, including my own, of course. It's still not considered a great look when a lawyer represents themselves, and there are some examples of that going horribly wrong, but no one will get in your way, because you're a lawyer, and that evokes a certain terror in court clerks, because they know that lawyers are an elite class of people, a class of people that rules the Western world in ways that most do not even comprehend, and a class of people that rather recently managed to completely destroy it. In this tiny, random Joe Johnson case, boy did it show me how.
Devil and he loaned me 20 bills. Spent the night in Utah in a cave up in the hills. Sit down, but I take my time.
If you're not already acquainted, that's the sound of the Maryland Chicken Wing Festival. It's held at the Anne Arundel County Fairgrounds each April. To be clear, I didn't record it myself. I've actually never been. The short clip you just heard was an advertisement of sorts for Dirk Schwenk. Appropriately enough, Dirk is a bit like the lawyer in the HBO comedy series Silicon Valley. When he's not lawyering, he's singing and songwriting at venues including, but not limited to, the Maryland Chicken Wing Festival with his band, Dirk and the Truth. And yes, you can pause here to check out Dirk and the Truth's website, which is just dirkandthetruth.com. They have a music video called Angel from the Train, and it's not really my jam. Dirk is more into country music than I am, but what can I say? I like that he's not a square. I like his politics, which lean progressive. And I'll tell you what I really like about Dirk Schwenk. He didn't ask for a retainer. His rate of $450 an hour was comparable to every other lawyer I spoke with in Maryland. Sure, some were a bit lower, maybe $350. But if I had to choose between $350 per hour with a $10,000 retainer up front or $450 per hour with no retainer, the choice was obvious. So Dirk it was. Dirk's law firm was not quite as intriguing as his rock band, but it was also, shall we say, not what I was expecting to settle on when I initially set out looking for corporate representation, having just not so amicably parted ways with the venerated nonprofit of Public Citizen. Dirk had a separate website for his firm, Bay Law LLC, with the Bay and Bay Law referring to the fact that his specialty was actually maritime and marine law, boats, yachts. The Bay Law site featured a photo of Dirk looking maybe a few years younger, with a chiseled jaw, which he was willing to put to work for you talking to judges, maybe to handle some pesky tax issues with your yacht. I didn't speak with him much before he agreed to take the case, just enough to glean that he had a kind of, yeah, screw this guy mentality about the whole thing. And given that I didn't really seem to have many other options, that worked for me. So I signed on the dotted line, so to speak, which was, in reality, an email with the magic words, I agree to the representation, in all caps. When you first hire an attorney for an ongoing matter, naturally they need to get up to speed. At minimum, that means getting a copy of all of the court filings. Oliver had been pretty diligent about forwarding me things by email as they were filed, but now that he was off the case, I had no way to view anything without him. So in September, I filled out the Maryland Judiciary's Form MDJ-004, which allows a party to a case to request access via MDEC, the Maryland Electronic Court System, which is just a Tyler Technologies case management software installation running on Microsoft Windows. Tyler's Odyssey platform is used by more state courts than any other system. If I had to give it a grade, I think it would be a C-. I've seen worse systems, but it would be a real stretch to say that Tyler's is good. Maryland in particular required this notarized form to establish a link between a user account and the Documents tab for a case, which is hidden by default. I was so outraged by the whole thing, I refused to get the form notarized. They processed it anyway, and I finally had access to my own documents a year and 3 months after the case was actually filed. But this newfound freedom to easily read about what was actually happening to my own company, really to me, did not extend to any other case. The rest of Maryland's court system remained off limits. But at least I could send Dirk everything he needed just by posting the documents on PlainSite. And here's the really exciting part. On PlainSite, I could assign them numbers. True innovation. Dirk got to work putting together a motion to dismiss for Joe Johnson's third amended complaint, which had scared the bejesus out of Paul. Compared to the extremely thorough legal briefs Public Citizen put together, maybe a Bentley if legal filings were cars, Dirk's draft was more like a 1987 Honda Civic missing 3 hubcaps. It would take you where you wanted to go, maybe, if the transmission didn't give out. But this didn't really surprise me. Bay Law LLC appeared to be a one-man show, and I knew from experience that solo practitioners often produce work that, justifiably in a sense, suffer from all the problems you'd expect to have given the lack of an extra pair of eyes, or an IT department, or a senior partner who knows all the tricks you need to know in Microsoft Word to generate a table of authorities. But as it turned out, the judges in Prince George's County weren't much better at grammar and punctuation themselves. Typos and questionable wording were endemic to filings from lawyers and orders from judges, the few I was able to view anyway. On October 19th, we filed the motion to dismiss the third amended complaint in conjunction with the motion for sanctions, asking for attorney's fees. Even though the motion to strike that I'd fought Paul for had been denied, which was a bit of a disappointment, I thought we still had a pretty good chance of success. Before it disappeared in a puff of smoke, Public Citizen had asked for a discovery stay and we'd gotten it, which meant that the court was kind of seeing things our way, and that Joe Johnson couldn't keep on demanding that I hand over my Social Security number. And the Maryland anti-SLAPP statute entitled us to an immediate hearing on the motion to dismiss. So I was surprised to learn, once it was filed, that the hearing on our motion wouldn't be a few weeks later in November 2023, or December, or January, or February. It was scheduled for March 12th, 2024, 5 months later. So we waited for 5 months. During that 5 months, a few things happened. First, I noticed that Joe Johnson had not just the hearing in my case to worry about on March 12th, but a second hearing in another case, Johnson versus Spirion Incorporated. I couldn't see the details, but just from looking up Spirion, it seemed like another case that had something to do with his BMW. The hearings were scheduled back to back, and they were noted as both being before the same judge, which was interesting. Joe Johnson also attempted to file a motion for partial summary judgment, but fortunately Judge Anderson shot it down after we asked to not be required to respond. Summary judgment is the stage after the motion to dismiss stage. On a motion to dismiss, you're supposed to pretend that you exist in a world with basically no facts, just laws. The facts are whatever the plaintiff puts down on the page in the complaint, and they're assumed to be true, even if they're kind of zany. The idea is to test the legal sufficiency of the claims. This is another one of those hard and fast rule of law things that has never made any sense to me, because obviously someone operating in bad faith could just put nonsense on the page. That then becomes the truth, which seems problematic. On summary judgment, the court finally looks at the facts to see if anything can be cited without needing a trial. Trial is for those 2% of cases where the facts are so ambiguous that a jury is needed to sort them out. If I could design a legal system from scratch, I think I'd put the fact-finding phase first, because thanks to the Twombly-Iqbal regime of the John Roberts Supreme Court, which in some ways has rubbed off on state courts, motions to dismiss are constant now, which they didn't used to be. So it seems like we're often asking courts to make legal decisions on factual scenarios that are just wrong. Does Law X say that this scenario is legal or illegal? Well, who cares if the scenario is really just a hypothetical set of words on a page that has no bearing on reality? Why not get the facts straight first and then decide what the law has to say about it? But that's not how we do things, and I've never heard a compelling explanation from a lawyer as to why. Maybe because it would be expensive? Well, I've got a solution for that, but I don't think lawyers would like it. Knowing that Joe Johnson's third amended complaint would be taken as true for the purposes of the motion to dismiss, a few days before the hearing in March, I went over the facts of the case with Dirk, as well as the claims, and asked him if he had any questions. He said he pretty much had things under control. The motion was fully briefed, so we knew Johnson's main arguments. He argued that litigation privilege didn't apply, he didn't want us to talk about fair report privilege, the kind of legal privilege that lets the media report on lawsuits, even inaccurately, without getting dragged into them themselves, which was exactly what was happening here. And he argued that this wasn't a SLAPP lawsuit. He also more or less argued that the company couldn't argue about personal jurisdiction because it had shown up in court, which sounded totally wrong. And he claimed that it didn't matter that he'd waited 6 years to file suit after he started emailing PlainSite about one of cases being visible in 2016. I was actually on vacation in February 2024 when a surprise from Dirk landed in my email. It was a forwarded message from Larry J. Feldman, Esquire, a lawyer Johnson had apparently just hired to represent him only at the hearing. Naturally, I was curious about who Larry J. Feldman was, so I looked him up. And very quickly I learned that he had been suspended from the practice of law, indefinitely. Yet, here he was, practicing law in Maryland on behalf of a convicted felon. When I dug further, I learned that Feldman had maybe been a little bit too helpful to one of his other criminal defense clients, having suggested that maybe one way to take care of a problem he had was, quote, the Sicilian option, or what most people would call a hit. His client took Feldman's advice, and while a federal trial was ongoing, that client's co-defendant was murdered. Mr. Feldman managed to avoid being charged by the feds, but he lost his ability to practice law in Maryland and Washington, D.C. For a while. Even though his suspension was, quote, indefinite, apparently getting someone killed isn't enough to be actually disbarred in Maryland, and within a few years, Feldman applied to get his law license back, and the state's Attorney Grievance Commission said, sure, why not? What could go wrong? They let him practice in state courts again. But he was separately banned from practicing in federal court, where we weren't, thanks to Judge Twong. Feldman seemed like exactly the type of lawyer I should have expected Joe Johnson to hire, and he didn't disappoint. To waste my money, he asked Dirk to send him documents from the case rather than getting them from Johnson or looking them up himself. I was not amused. I sent him an email and CC'd Dirk, telling him that if he intentionally wasted any more of my money by pulling similar stunts, I would report him. Dirk was upset that I dared send an email on my own. Feldman was upset that I was threatening him for good reason and made up a rule that doesn't exist. A rule saying I can't email lawyers for the other side. While there is an ethics rule that forbids communicating directly with represented parties, because you might take advantage of their lack of legal acumen, you can of course always contact their attorneys. It was nonsense. I told Dirk to calm down, and he did. The night before the hearing, there was a scramble to figure out how I could actually attend remotely. The court had a Zoom option, probably only thanks to the COVID-19 pandemic, but its web-based form to request access didn't work. Since the hearing was scheduled for 9 a.m. Eastern Time, I was up at 5:30 in California in dress clothes, calling the judge's chambers to see if I could get the link I needed. At the last minute, everything came together so that I could listen. The Zoom setup was just the judge's laptop, so I couldn't see the courtroom or anyone in it. I could just barely make out the audio, and I had a very close-up view of Judge Anderson herself. It took a few minutes for the court to come to order, for the case to be called, and for the judge to check to make sure I could hear, but finally things got rolling. Dirk started explaining the case, and I was a little surprised to hear that he decided to skip over kind of everything I thought mattered. What you're about to hear has been edited for time and audio quality issues. If you'd like to hear the full unedited recording, you can find it on the PlainSite YouTube channel. This is Dirk.
Your Honor, as you noted, we're here on two motions, well, really one motion. Motion to dismiss, but it includes a motion for sanctions. This case is a SLAPP suit, a strategic litigation against public participation case. We're still making that motion. There's a statute of limitations argument, which has been briefed, but I'm not particularly emphasizing that because it's somewhat factual. There's a Section 230 Communications Decency Act argument in there. I'm not emphasizing that. It's been briefed. It's incorporated in this case. I think it's relevant, but the Maryland courts have never really looked at Section 230. There's a personal jurisdiction case or argument that we're maintaining. There are not sufficient contacts with Maryland, but here we are in this matter, so I'm not focused on that issue at the moment. There was a June 15th, 2023 motion to dismiss filed with an affidavit attached in this court. For example, in some of the briefing, there was some excerpts of some of the emails back and forth. That's all incorporated in that affidavit. It also includes some background on PlainSite and what its business is. We have argued that Mr. Johnson's case here is simply an effort to extort sort of nuisance settlement for the fact that PlainSite has published legal information dealing with Joseph Johnsons in this state. And there are numerous Joseph Johnsons. There's Joe Johnson that is here as this plaintiff, although he's not really identified in the complaint. There's other Joseph Johnsons that are in Prince George's County that have filed a lot of cases. It's somewhat difficult to tell who is who. As best we can assess what his complaint is in this case, it is that presenting to the public pleadings that include his name are somehow a violation of his rights. There's numerous problems with that argument. First of all, and this is the essence of the SLAPP suit argument. A SLAPP suit is a publication is attacking someone who presents information that's First Amendment protected, and you use litigation in an effort to suppress that publication. This litigation is clearly intended to stop Think Computer from publishing information about Joseph Johnson's and their litigation practices. So that is the essence of a SLAPP suit. This case should be dismissed as a SLAPP suit. SLAPP suits, upon dismissal, you can get attorney's fees for them, and that's the appropriate result in this case. Two other main issues that I would raise here. One is Maryland recognizes absolute privilege, and I've never had to argue absolute privilege in my life, but the absolute privilege protects all communications about litigation, about the instant litigation, about other litigation, publishing litigation information, litigation dockets, litigation pleadings, discussing pleadings and cases in the press or in the public, is protected by absolute privilege. It's just plain. If you're talking about litigation documents, it's privileged, and there is no case for that. The other argument, and this is slightly more nuanced than those two, but reading the complaint as a whole is essentially an effort to, without providing any specifics about what was quoting what was published, giving, a citation to where it was published, to whom it might have been published. It is an effort to create sort of a false idea that the minimum pleadings have been satisfied without giving any actual notice of what it is that is alleged to have been defamatory or otherwise a violation. Maryland Rule 2305 says that pleadings have to be, or complaints have to be, with such reasonable accuracy as will show what is at issue between the parties, so that, among other things, the defendant may be apprised of the nature of the complaint he is required to answer and defend. And this goes also to Mr. Johnson's habit of trying to delay issues being dismissed, trying to create litigation where there is none, where there are no real issues. There is no way to tell, reading the complaint, what are the complained of statements. In defamation, there is no way to tell, reading the complaint, who Mr. Johnson is. And so a big part of his complaints here is that there's defamatory information being published about him. But who he is not revealed by the complaint. Is he Joe Johnson Jr., which is in some of the pleadings? Is he Joe Johnson, the person that it says is in the complaint, who has a post office box but no other identifying information? Is he the only Joe Johnson in the East Coast? I have honestly no idea, and there's no way to tell from this complaint. So those are the three. Those are the three big issues, all of which I think are grounds for dismissal. This court can also take judicial notice of Mr. Johnson's activity in this court, his statements, his prior findings as a vexatious litigant in this case and other cases, much of which is laid out along with the affidavit of Mr. Greenspan. And I know some of which this court has observed for herself. I know there's another hearing on this with this plaintiff today that deals with some of these similar issues. All of those things, his history, absolute privilege, and the fact that this is a SLAPP suit, all are grounds for this case being dismissed, for sanctions to be awarded, and we will move for sanctions and attorney's fees in due time, assuming we can get an order. The plaintiff is barred from filing any future suits in Prince George's County without prior permission from this court, and plaintiff is barred from filing any suit against the defendant in any court without permission of this court. All of those things are justified by Mr. Johnson's conduct in this case and other cases before this court. And I'll close with that, but I would just hope you would keep in mind the question, if there's going to be discussion of defamation, who is the plaintiff in this case, and what right does he have to say that every Joe Johnson or no Joe Johnson is him at any one particular time? Thank you, Your Honor.
Thank you.
This is Larry Feldman representing Johnson.
I'll try to respond in the same order in which able counsel argued. But the first thing I want to point out is, no matter what the history of this case, we are still at preliminary motion stage, Rule 2.3.22. I find it hard to believe that they're arguing that Mr. Johnson's been delaying things when they asked for removal to the federal court and tied up the federal court for some 10 months and before it got remanded back here. So I don't believe my client has done anything to delay. He had a right to, the rules give him within 30 days of a trial to amend his complaint. So we are far from that point. So At this stage, the court must review the complaint on the four corners of the document. That's well-established law. So the affidavit of the defendant is absolutely irrelevant, and the court should give it absolutely no weight because it's not within the four corners of the pleading that they are seeking to dismiss.
This is Circuit Court Judge Tiffany Anderson.
Well, I agree with that. I'll let him respond to that. But with regard, for a motion for summary judgment, the court can take another document. For the motion to dismiss, it should be just the four corners.
Well, first of all, I don't think, as a slap suit, I don't believe you're required to just look at it strictly on its face.
For the motion to dismiss, well, for the slap suit, you're saying that I would not look at the four corners? What are you citing with regard to that?
It's clear from Judge Anderson's question here that she doesn't actually know what Maryland's anti-SLAPP law says or does. It's entirely plausible that as a sitting judge in Prince George's County, she'd never even seen an anti-SLAPP motion before. Dirk wasn't arguing that she shouldn't read whatever was in the, quote, four corners of the complaint. He was just saying that once she read it, she'd realize it was about shutting down free speech. Here's how Dirk handled it.
Well, I think it's necessary in a slap suit to look at the context which it has been filed. I think that is inherent. I don't know if there's any case law on that, but it's inherent in a slap suit that you have to be able to look and see whether this is, whether these things are, whether the defendant, without constitutional malice, reports on, comments on, rules on, challenges, opposes, or in any other way exercises rights under the First Amendment. You're going to have.
But is that a motion for summary judgment versus a motion to dismiss?
That is a motion to dismiss, is my understanding, Your Honor, because you're allowed to do this, and you're supposed to get an immediate hearing prior to any other activity.
Do you have a case that you want me to look at with regard to the slap suit and what's supposed to be, the court is supposed to look at?
I will, once I sit down, Your Honor, I'll take a look at that real quick because I didn't put that in my case right here. But the other issue I would say is that with respect to PlainSite itself, the plaintiff has raised the existence of that website in its pleading, and therefore I think, and not just I think, but I have citation to support that this court can take a look at that, and I think you need to take a look at that.
To take a look at what?
The website itself. So if you look at...
Which paragraph in his amended complaint?
Well, the defendant, he's identified... sorry, Your Honor.
As you can hear, and as I could hear live, there are a lot of pages flipping and a lot of awkward pauses. I wouldn't say Dirk was entirely unprepared, but he often sounded uncertain and like he was trying to catch up. That wasn't good. With the court clock's second hand ticking in the background, I edited out about 80 seconds here of Dirk shuffling pages, not able to locate what he was talking about, before Judge Anderson found it first. I wasn't thrilled.
That's where he cites the website. Is that what you're looking at?
Yes, Your Honor. Thank you. That does identify the website. And so...
So he cites the website because of the term vexatious litigants.
And I think if you did, maybe, I'm not sure whether it specifically says later, but the entire context of this is things that are published on PlainSite's website. That's all PlainSite does. So yeah, you can bring that in.
Dirk gave Judge Anderson a case citation saying she could look at my affidavit, even though this was a motion to dismiss, because Johnson had raised PlainSite first by putting it in his complaint, and by that point she was confused as to what he was even talking about. Then Feldman continued his argument. Once he got tired of harping on the four corners, he invented a new legal theory, that strategic lawsuits against public participation can only be about published materials that are 100% true. That's not how it works. Imagine getting sued for voicing your opinion at a public hearing at your local city hall. Public participation isn't always provably true and grounded in fact, and it doesn't need to be.
I don't think he's told you anything that allows you to go outside of the four corners. He is suing the defendant because they own a website. That doesn't open the door for exhibits and affidavits. And I'm looking at the slap suit statute. It's really a matter of timing.
It opens the door with regard to what I just read in number 8. Would you agree or disagree?
Well, I would
agree
that
the plaintiff, along with 6 others, were vexatious litigants, and that's on the PlainSite.org. So that part is brought into the complaint.
Well, no, it's his allegation, but I still don't think it gets you anywhere outside of the four corners of the document. That's my position.
I think it gets us as far as the PlainSite website, where those terms are used.
You can't say it's a slap suit for violating the First Amendment rights to publish what's going on in the courts, or you can't say absolute immunity from the courts if you're stating a falsehood. That takes you back to the law school statement that you have...
So you're saying that the term vexatious litigant is the falsehood?
No, I'm saying the fact that they've published that he is a litigant in this case is it is his name, his date of birth, and a list of lawsuits that he was not a party to. I have exhibits for 2 of those, Your Honor, and I can pass them up at the appropriate time.
Sure, you can do that now.
Okay, sure. So, in terms of the defamation, and again, we're talking prima facie case here. Counsel, do you have the copies or you need other ones?
I'll take a copy.
Okay.
So, for a defamation case in Maryland, you need to prove that first that the defendants have made a defamatory statement to some third party, and then you have to show that it was false.
Correct, Your Honor. And
then there's some legal basis that they're at fault
Right.
for making the statement.
Right.
And then there's some harm that
Right.
has occurred. The harm is
at
the other part.
a prima facie level at this stage. And Your Honor,
What am I looking at?
you're looking at 2 of the lawsuits that were in the counts. Those are the only 2 I was able to get from the district court. The other 5 were sent to Annapolis. I can't think of the word. They were they are no longer in the courthouse. They were indexed and sent to
They're
Annapolis.
not in index?
No, they're not. These are 2015, 2016 cases.
Why wouldn't they be an index?
They didn't scan all cases into MDEC, Your Honor. We literally had to come to the courthouse to get these sets of documents.
But these are not certified, these are just copies?
These are copies taken from the clerk's office of the district court.
But they didn't certify?
This was a remarkable exchange. First, Judge Anderson correctly outlined the requirements for a defamation claim in Maryland. And then, by repeating the phrase prima facie, meaning on the first impression, Feldman evaded the obvious fact that Johnson's complaint met none of those criteria. Then he presented to the judge copies of 2 lawsuits that Johnson alleged were about a different Joe Johnson Jr. in Maryland, documents that were never actually posted on PlainSite because, as Feldman himself admitted, even he had to obtain them from the court, where he didn't bother getting the copies certified to guarantee their authenticity, while he represented Joe Johnson, a man repeatedly convicted of forgery. The rest of the documents he wanted were unavailable because they were archived, the word he couldn't think of. And this confused Judge Anderson, who appeared unaware that the very court she worked in had been on paper filing from 1851 through October 2022. So of course nothing would be an MDEC from that period unless the clerk specifically scanned it in first.
Those cases are listed on the defendant's website being associated to my client, but they're not him. They're a different address, they're a different person, they're a different social security number. Again, I don't believe it's my burden to show this at this point, Your Honor.
So I just want to be clear, you're saying that the Joe Johnson Jr. in these exhibits that you're showing me, we're marking these exhibits 1 and 2, they're district court civil complaints from 2018. You're saying that these complaints were listed on PlainSite's website and they're not your client?
They're not my client.
And they're listed on the website as belonging to him?
Under his page, so to speak, his formatted page as this fictitious litigant, yes. They are, as well as a tax lien that doesn't belong to him. So, but we don't even get really to that point. The only reason I bring that forward is for this First Amendment or absolute immunity. Because you don't have a First Amendment or absolute immunity right to yell, as I was getting to, you can't yell fire in a crowded movie theater.
So I guess I'm confused because in these cases he's the defendant.
Yes, but it's not him.
Either way,
Yeah.
I'm assuming if someone is saying someone is a vexatious litigant,
Right.
that they are the plaintiff. They're suing people, not being sued.
Feldman didn't mention that the PlainSite profile in question was under the name Joseph R. Johnson Jr., yet the plaintiff here was suing under a different name, Joe Johnson. There were 6 cases obliquely referenced in the third amended complaint, not 7 like Feldman said, and if the cases being referenced weren't actually Joseph R. Johnson Jr.'s, then who cared? Apparently, he wasn't the guy suing. Joe Johnson was. How could Joe Johnson have standing to sue for supposed harm to a different person? As for the vexatious litigant designation, Judge Anderson was right to point out that the gripe didn't make any sense, since vexatious litigants are always plaintiffs. But she was confusing issues from one defamation claim in the lawsuit with 7 other claims, 6 for defamation and 1 for false light. Johnson was arguing that he was defamed both by being called a vexatious litigant and by being associated with the 6 lawsuits that weren't his.
You can't be vexatious if you're not suing.
Well, that's a separate count, Your Honor. We also have, well, there's 7 counts of, I believe, of defamation.
Which count are you?
Okay, so, Your Honor.
Count by count so I can.
Yes, let's absolutely do that. And I will tell you, count 10, I would voluntarily dismiss.
Okay.
This is not a commercial law
Thank you.
matter, so I would definitely say that that does not carry forward. Okay? However, count 1 includes all of the cases, intrusion upon seclusion. Count 2, defamation, includes all of the lawsuits. The specific Platinum Financial Services is one of the cases I put, portfolio recovery. Platinum Financial.
I'm sorry, which count are you on?
I'm in count 3. I won't say I wouldn't have handled some of these other pleadings differently. But this is where we are. Because we've met the elements of defamation. Damages, he's saying he's damaged. At this juncture, we don't need to show a medical bill. We don't need to show medical reports, psychiatric reports. I mean, that's for a trier of fact. That's for the jury to decide. We're in a motion to dismiss. So 3 through 8, I would link together.
So was the term vexatious litigant used on this page?
Yes, it was.
Okay.
And it was used, to me, the way I look at the website, as a summation of all of the cases he's been involved in as a plaintiff and a defendant. They wrote the website. They published the website. Again, they have an obligation to seek the truth before associating something with somebody's name, or perhaps be liable for defamation. And I say perhaps, because again, all I need to show at this juncture is a prima facie case.
I agree with that.
By publishing this website under his name, without figuring out, is he Joe Johnson, born in 1967? Is he Joe Johnson Jr., born in 1978? A reasonable trier of fact could find recklessness. So again, I would argue that at the prima facie case level, that counts I think that was, are we up to 11? No, that's 9. 10 and 11, I would dismiss.
Well, it doesn't say that, but yes.
Well, but I'm saying it doesn't say that, Your Honor, but the Maryland rule on preliminary motions says that at this point it's in the light most favorable to the plaintiff, a prima facie case. I mean, it's nothing more than me saying, I stepped out into the roadway and I was hit by a car. Well, maybe I didn't say exactly what road I was on and what color the vehicle was that struck me, but I passed the smell test and the prima facie test.
The count-by-count explanation went on for a while. Feldman, on behalf of Johnson, dismissed counts 10 and 11 voluntarily. Judge Anderson then turned to count 12 for intentional infliction of emotional distress. She wasn't impressed.
It just says harass. He names that he's harassed the plaintiff by publishing the website. It doesn't say how he's harassed, how he has been impacted.
But this is the form complaint. If you went into the library and looked up a form complaint for intentional infliction of emotional distress, this is what it would say.
Sure, but
because
you still need to have some. You need to have some facts that support it. You can't just say it.
I'm happy to limit my focus to the counts 2 through 9. Personal jurisdiction, Your Honor. They filed discovery in this case. It wasn't even time for discovery, but they filed discovery requests in this case.
This was a flat-out lie. Johnson filed for discovery. Think had to answer it, and then we stopped it. Then Feldman shifted to a different argument, that running a website means that every court has jurisdiction because the internet is worldwide. This is the opposite of what every court that has ever analyzed the issue has found.
I think at this point in 2024, if you're running a website, you're submitting yourself to jurisdiction anywhere that website could be read.
Then, Dirk was up again to rebut Feldman's arguments. He began by going back to the anti-SLAPP question.
There's not a lot of case law in Maryland about slap suits.
But you're saying it's First Amendment protected, which means it has to, I mean, he's saying here that at least in these two documents he's shown the court.
Frankly, this complaint is specifically drafted to try and avoid this particular question. So for one thing, with respect to this defamation issue, and I sort of, noted for the court that this question of who the plaintiff is an open question that is not answered by this complaint, or anything else that's ever happened in this court as far as I'm concerned. But
when you mean who he is, I mean,
so
he's saying
yes.
in his motion that because, for instance, I have a comment on Tiffany Anderson.
Correct.
And that if Tiffany Anderson is arrested for something, and it's not me, and someone else, and you associate my name and my address with the Tiffany Anderson who has been accused of some crime or some type of civil litigation, and it's not me, that is defamation, and that's not First Amendment protected.
Well, that's the argument, Your Honor. But
that's his argument.
I understand.
And that's his argument at the motion to dismiss stage.
There's no address in the complaint. He uses a post office box in this case, and so I have no idea which Joe Johnson this is. And it's not an accident that I have no idea which Joe Johnson this is. It's intentional. The complaint does not say who this is, and therefore there is absolutely no way to determine whether this different Joe Johnson Jr. in some other case in Prince George's County is in or not.
And if there's no way to tell, how do you then combine them to say someone is a vexatious litigant?
This is where Dirk really screwed up. He was trying to argue that the complaint wasn't specific enough to withstand a motion to dismiss, and it certainly wasn't. But by saying that nothing that had ever happened in the Prince George's County Circuit Court could answer the question of who Joe Johnson was, he revealed that he hadn't done his homework. We knew exactly who he was, and we knew that because of the other 100-plus cases I had found that he had filed, most of them in that court. With only light editing, here's how Dirk more or less responded to the judge taking Johnson's side, because she too had a common name. So this was not going well, and it wasn't like Judge Chuang where the judge was audibly upset. By taking a wrong turn and arguing that he had no idea who Johnson was, instead of saying that we knew exactly who he was, a repeat convicted felon, a forger, a vexatious litigant, a con artist who targets courts, Dirk had just given up the motion and maybe the entire case. I was texting him furiously, trying to steer him back on the right track, but he clearly wasn't looking at his phone.
So, I don't believe that these cases, and we don't have the facts in front of this. Counsel says these cases are attached to the PlainSite listing on Joe Johnson. I don't believe that they are. And there is, in fact, a Joe Johnson, this plaintiff.
So if we're at the point where we're saying you don't believe that they are, and he's saying that they are, then this is not failure to state a claim upon which relief can be granted. It's the motion to dismiss stage and not the summary judgment stage, which is completely different and a different standard.
In a normal case, I think that would be true. This case is not a normal case.
The nervous laughter told me that he knew things were not going well.
That means there's a genuine dispute, right, at this point. I'm sorry, that's the summary judgment language. But he's stating a claim upon which relief can be granted. Now, whether or not in discovery it comes out that what he's saying here in these two documents is not the case, then there's no genuine dispute.
Dirk was ineloquently calling out Feldman, a lawyer who had been indefinitely suspended from practicing law but was somehow back, for lying. And Judge Anderson's response to that was to treat it as a dispute over facts, which meant that the motion to dismiss should be denied so that we could get to summary judgment. The hearing went on for another half hour. It was maddening. Judge Anderson correctly pointed out that there's a difference between guessing at who is a vexatious litigant and knowing that someone has been found to be one on the record. She told a story about another Tiffany Anderson who was a criminal while she was a judge. Dirk didn't manage to convince her that we knew that our specific Joe Johnson was one for certain. She confused the standard for summary judgment with the standard for a motion to dismiss, saying that because there was a genuine dispute, that meant Johnson had stated a claim. Then she turned back to the vexatious litigant issue. At first, she argued that Johnson would have to be found to be a vexatious litigant in every lawsuit he filed But then she corrected herself, realizing that that's not how vexatious litigant designations work. You only have to be declared one once. At which point, she said this.
If you had an order from a judge that said, this person has been found to be a vexatious litigant, and the court has made a finding that he has filed these 25 cases, and they list those case numbers or their jurisdictions that they're in, and this is why we found him to be a vexatious litigant, right? So if they're saying that, then you can name it vexatious litigant because the court order has called it that.
Over Zoom, I asked Judge Anderson if I could speak, because we did have a court order stating that Johnson had been sanctioned for filing a frivolous appeal, a case where he had been called vexatious. But she refused because Think was represented by counsel.
So Your Honor, and maybe this goes too far into the truth of the matter versus the reality, but this defendant has been found to be a vexatious litigant, including in the Fourth Circuit, and those are both...
That's the order that you attached?
Those are in this site, and they're in the affidavit. They're in PlainSite, the order that shows him as a vexatious litigant.
So, but they would name the cases and what it is. And again, did they find him or did they find another Joe Johnson? That's your question you asked earlier.
Dirk decided to try to salvage this fiasco of a hearing with one last issue, asking once again, who is Joe Johnson? Instead of reducing confusion, he kept adding to it. And yet, after succumbing to the confusion on seemingly every front, Judge Anderson took Dirk up on his offer. She put Joe Johnson, who was there, even though I couldn't see him, under oath.
The identity of the plaintiff is a pleading matter. You have to be able to say that the person that is in the complaint is a real party in interest that exists. And there's a person sitting here, and he has filed a complaint under Joe Johnson. But that person, I don't know how you could possibly say. It's got a post office box. I don't know how you could say who that person is. He's saying he's not this person via counsel, but not in any kind of pleading or under oath. I don't know how you could get to that point. Look at paragraph 1, Your Honor. Sorry, paragraph 2. Plaintiff was a resident of Prince George's County, Fort Washington, Maryland. That is all we know about the plaintiff.
And so you're saying that he must assert what?
That he has is he a resident presently of Prince George's County? Is he, who is he? Is that his full name, Joe Johnson?
He doesn't have to allege that.
All right.
He doesn't. I mean, he needs to. He's filed in Prince George's County. So if you're raising jurisdiction, did you raise jurisdiction in York?
Yes, Your Honor.
Let me go back. His address is listed as well. His address is not listed on the plate, actually, which is he's supposed to list.
Correct, Your Honor.
It's in the cover sheet. It's a P.O. box in Fort Washington, Maryland. That's where he gets his mail.
Do you live in Fort Washington, Maryland, sir? Let me put you under oath before you answer that. What's your full name, sir?
It's Joe Johnson.
Your birth certificate says Joe?
Yes, ma'am.
Not Joseph?
No.
Okay. And are you a junior, first, second, third only?
I'm just a Joe Johnson.
Okay. I'm saying you're not a junior?
No, ma'am.
You're not a first or second?
No.
Okay. And Mr. Johnson, what is your address, please, for the record?
It's P.O. Box 441572, Fort Washington, Maryland.
No, what is your physical address that you live at?
I've edited out Johnson's address here.
Brinkley Road?
Yes, ma'am.
In Fort Washington? And that's where you presently live?
Yes.
And you lived at that address when you filed this lawsuit?
Yes, ma'am.
Okay, thank you.
Though I could barely hear him, Johnson said that he lived in Prince George's County, not just that he had a P.O. box there. And that was it for arguments. Judge Anderson read her ruling on the motion from the bench.
The court, with regard to count 1, invasion of privacy by intrusion upon seclusion, the motion to dismiss in that manner will be granted. In count 1, they're very bare-bone facts that do not rise to the level what's required for to state a claim upon which relief can be granted for invasion of privacy by intrusion upon seclusion. Therefore, count 1 will be granted. With regard to count 10 and count 11, the plaintiff has voluntarily dismissed count 10 and 11, so those will be dismissed. With regard to count 12, intentional infliction of emotional distress. With regard to a claim of intentional infliction of emotional distress, the plaintiff has to allege that the conduct was intentional and reckless, that the conduct was so extreme and outrageous that there's some causal connection between extreme and outrageous conduct and his resulting distress, and that this emotional stress is severe. What's alleged here in count 12, I believe?
12.
Yes, in count 12, is not, what's alleged here, the court does not find goes beyond the bounds of decency as are required by the case law, because it's a very high standard. So with regard to count 12, the court is going to grant the motion to dismiss. With regards to counts 2, 3, 4, 5, 6, 7, and 8, what is alleged, again, the court, for a motion to dismiss, the court has to find that there's a failure to state a claim upon which relief can be granted. This is the initial stage. The court has to abide by the four corners of the document. The court has reviewed the 30-minute complaint. That is the latest complaint that's been filed. And based on that complaint, there's enough that is alleged for them to go forward. Now, whether or not that sustains a motion for summary judgment is a different question.
It was a disaster. Because counts 2 through 9 survived based on Judge Anderson's profound confusion, the case would go on and there would be discovery. If we didn't win on the motion for summary judgment, there could be a trial. And in theory, Think could be on the hook for millions of dollars in damages for publishing public records. So far as I could tell, for $450 per hour, Dirk had tried his best, but his best just wasn't good enough. Throughout the hearing, he sounded uncertain and confused, and the way he worded his points only added fuel to the fire. Confusion was exactly what Johnson wanted. Personal jurisdiction didn't work because Dirk didn't push back on Feldman's lie that we initiated discovery. The statute of limitations and Section 230 each didn't work because Dirk just skipped them. Anti-SLAPP didn't work because Judge Anderson had no idea what it even was, even with Dirk telling her. Logic didn't work because Feldman confused her with 2 random exhibits he lied about, but mostly because at every opportunity, rather than being decisive and clear, Dirk left everything open to uncertainty and questions. Somehow, these 3 lawyers, one wearing robes, all managed to take a fraudulent complaint with virtually no facts in it whatsoever, and argue their way to the conclusion that it met each of Maryland's 4 required elements for defamation claims, the only question on a motion to dismiss. I told Dirk, as politely as I could muster, that I considered the loss to be his fault. In response, he sent me a bill for thousands of dollars. As for Feldman, he was done. His representation of Johnson terminated the moment the hearing was over. But Dirk and I, we were just getting started. Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. With the exception of court audio and the music you heard from Dirk and the Truth, everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the Dolly image prompting, that's my doing. Until next time, I'm Aaron Greenspan.